On 23rd of March 2020, an announcement was made by the Honorable Prime Minister Shri Narendra Modi ji with respect to the biggest lockdown in the entire world. 1.3 billion people of our country were requested with folded hands to remain where they were and to stay at their homes. This casted a huge impact on everybody, and the worst hit people were the migrant laborers. Hello, everyone. Welcome to Indian Legal Talk Show. We are going to make an endeavor to understand the problem, pain, and the sufferings of the migrant workers during lockdown. From legal point of view, we are going to make an attempt to understand the process of adjudication taking place in this regard. Due to imposition of strict lockdown, our country came to a standstill wherein no activity of any kind was allowed. The miseries of the migrant laborers started as soon as lockdown came into force. The people whose livelihood was dependent upon their daily earnings were severely affected since there was no work. So migrant workers who used to earn their livelihood on daily basis virtually became insolvent. In many cases, the migrant workers were only the bread earners for their families, so their pain aggravated when they have to feed their family in such a situation where they were penniless. Therefore, due to meager financial resources at their command, it became extremely difficult for them to feed their family. Most of them decided to go back to their respective places from where they belong. So now here their sordid tale began. Since there was complete and absolute closure of all kind of transport, be it rail, bus, car, there was ban on every kind of movement. This aggravated the problem for migrants. They were facing human right violations. They were not getting food to eat, water to drink. They were not having proper sanitation facilities. Under such circumstances, Alakh Alok Shrivastava, a public spirited person understanding the miseries of the migrant workers, approached the highest court of the country for protection of basic human rights. The court proceedings which initiated by filing of this case is further dwelled by Sagar. Sagar, kindly help us in understanding as to what happened when this matter reached the court.
Thank you, Tanya. In the petition filed by Mr. Shrivastava, the case of migrant workers reached the Honorable Supreme Court of India for the first time. Now, in this case, the petitioners had sought directions against the respondents, that is, center, as well state governments, to immediately identify moving as well stranded migrant workers and shift them to nearest shelter homes and also provide them with proper food, clean drinking water, medicines, and medical supervision in a dignified manner. An application was filed with a prayer that immediate rehabilitation of migrant laborers without charging any cost for transportation and 1 month statutory wage along with free ration shall be provided to them. It was further prayed that a board should be constituted which may be called as Migrant Labour Crisis Management Board, and 24 hours multilingual call facility was also prayed for. The Honorable Court ordered to file a status report both by state and central governments with regard to migrant workers as to what measures have taken for them before the next date of hearing. Subsequently, a similar petition titled Rashmi Bansal vs. Union of India was filed and clubbed with earlier petition filed by Mr. Shrivastava. Both the petitions were jointly listed for 31st March. On the next date of hearing, parties were heard. During the course of arguments, learned Solicitor General representing Union of India averred that 21,064 relief camps have been set up by various state governments and union territories where the migrant workers have been shifted and basic necessities are being given to them. According to the status report, 6,66,291 have been provided with shelters and 22,88,279 with food. Learned Solicitor General also stated that there is no person walking on roads to reach homes or villages. Advisories issued by the Ministry of Home Affairs on 27th and 28th March were also mentioned in the report, according to which directions was given to state governments, union territories to provide adequate facilities for migrant laborers. It was further contended by Learned Solicitor General that the fake or misleading news has caused a panic situation for migrant workers. Learned Solicitor General also assured the Honorable Court that within next 24 hours the trained counsellors or community leaders belonging to all faiths will visit the relief camps or homes and deal with the consternation that the migrant workers might be going through. Further, the Honorable Bench stated that the anxiety and fear of migrant workers should be understood by the police and other authorities. As directed by Union of India, they should be dealt in a humane manner. Considering the situation, the Honorable Bench opined that the state governments and union territories should endeavour to engage volunteers along with the police to supervise the welfare activities of the migrants. Section 54 of Disaster Management Act 2005 and Section 188 of Indian Penal Code were implemented. It was further ordered that all the concerned shall comply with directions, orders, and advisories passed by the Union of India in the interest of public safety. After that, the matter was listed on 3rd April. On the date so fixed by the Honorable Court, an interlocutory application was filed in which it was prayed that the government should use hotels, resorts, government guest houses, state bhavans, sadans for shelter homes. Per contra, Learned Solicitor General averred that contents of application along with prayer made have already been taken care of. Suggestions put forth in order to requisitioning exercise of private properties are being carried out. The Honorable Court observed that since the Learned Solicitor General has not refuted from the contents of the application and has further disclosed that whatever has been prayed for is being carried out, therefore the Honorable Bench did not find it convenient to pass any order. Henceforth, in the above terms, the application was disposed of, and the matter was listed further on 7th April. On the next date of hearing, no substantial order was passed, and the matter was listed after 2 weeks. On the next date of hearing, the Honorable Bench observed that the interim directions passed by the Honorable Bench on 3rd April should be continued, and the suggestions made in the interlocutory applications should be examined, and appropriate actions would be taken on such suggestions, and therefore the petition was disposed of on 27th April. So this was the first petition filed. Consequently, another petition was filed titled Harsh Mandir and another versus Union of India. Since it won't be convenient to have a discourse about it in this video, so that case would be discussed in the upcoming sequel. Thank you.
Thanks, Sagar. So this was all for our today's video. Kindly like, share and subscribe this channel so that we stay motivated to bring you more such videos. Bye bye.